Okay, that brings us to matter 42223, Patricia Foster Skelton. Mr. Lee and Mr. Veltman.
Veltman commences. Ms. Skelton has been conferring with Bob Galvan, who is one of her lawyers in the trial below, and we would request that he be allowed to sit with me at council table during this proceeding.
That'd be fine.
Thank you.
And I would just make sure to remind people we're not planning on taking a lunch break. We are not planning on taking the lunch break. We plan on going through. As you might expect, our attention span as we get hungrier kind of gets a little less. So getting to the points probably has some benefit to both parties. Ready for his opening? Are you prepared? Are you ready?
I was just looking at one thing that occurred to me in the drive here this morning when I submitted my exhibits electronically to your staff. I lettered them rather than numbering them, and so I was going to wonder if that was going to cause any confusion or...
I think we'll be able to...
I think ours are lettered as well.
Yes, so we've got two
then I assume Mr. Veltman has no objection to letters. That'll be fine. Mr. Veltman, go ahead.
Turns out Mr. Lee knows the answer to this.
Patricia Foster Skelton was indicted on November 15, 2004 for forgery. She was later found guilty of forgery on January 10, 2008. She appealed. We entered into an agreed interlocutory appeal. She lost the appeal. The commission is here asking for a final order of disbarment. That's it.
Mr. Lee?
If it please the board, it is correct that Ms. Skelton was indicted for and convicted of the offense of forgery. She has complied at all times with her requirements to the bar. She entered into an agreed interlocutory suspension while prosecuting her appeal. Her appeal was, in fact, unsuccessful, and the mandate has issued. However, also, since this is a case in which the decision is made as to whether she should be suspended during the term of her she was given a fully probated sentence, and in fact, the record will show she was given the least possible sentence for the offense of forgery, 1 year confinement, fully probated for 2 years, no fine. This was about a will that was executed in her office. Along the same track, the will was being contested, and the evidence and record will show that the will that she purportedly forged, or that a court found she was guilty of forging, has been admitted to probate as a valid copy of the will. Questions were submitted to the civil jury in the will contest as to whether she had the intent to deceive anyone in the creation of the replica, the duplication, the copy of the will that she prepared as a lawyer, and the jury found no, she did not. Also, we have here her criminal defense appellate attorney, who will testify to the extent the board permits her to or wishes, but that she finds the case, the criminal conviction, have been such an egregious miscarriage of justice that she has filed yesterday a writ of habeas corpus asserting actual innocence. So what we're here for is to try to hold this sanction down to a suspension. If the writ is successful, that may change things, and it may not. But disbarment is simply, in my view, the view that I'll be articulating, not called for. Public protection does permit suspension during a pending period of probation. It's there for a reason. The public has been protected from Ms. Skelton if they needed any. She's been out for 5 years, and she will be out for another 1.5 years if we prevail, and she'll be disbarred if we do not. And so I want you to hear about the will contest trial. I want you to consider her character witnesses, and with all due respect, I respectfully urge you to merely suspend her during the conclusion of her probationary period. Thank you.
Before we begin evidence, I think we may have some questions for you. I know I'm kind of curious. Is it your position that we need to, in reading the rules, it appears that we have to take as true the criminal conviction in the elements of the crime? Do you have any authority that...
I would agree with that, and I'm not asking you to disregard it and exonerate her and turn her loose. I mean, we're trying to hold this down to a suspension. And the reason we're offering the proof of the other case is simply to show that this is not the kind of egregious conduct that everyone would agree was wrong, was done maliciously with some intent to injure, that another jury, looking at the actual validity of the will itself, not merely her intent, said, this is a valid copy. This represents the donative intent of the decedent. And so that just kind of goes to the nature of whether her conduct was evil and malicious or merely mistaken and erroneous. And mistaken and erroneous.
If it was mistaken and erroneous, would there have been a conviction?
I would.
And isn't
I
that
think, without regard to the facts, and I don't know if this is anything we can go into, and I probably shouldn't even talk about it, but I think there would have been a prosecution. And I would simply say to you that the conviction means that she is a person who has the status now of convicted and is on probation, and we're not asking for excuse from that. But we are trying to show the circumstances surrounding to indicate her mental state. And, well, really, it's what's fair for her and what will protect the public. And if the evidence were such that, well, I guess I don't want to tell the State Bar how to try their case. I know what mine is. I'm just trying to demonstrate that Ms. Skelton acted in good faith. Her conduct was found by one court to be a crime. She accepts and acknowledges that. But I think she's entitled to explain what her thought processes and the surrounding circumstances were, so you can judge whether to treat this as a serious crime or an intentional crime. Does that answer your question?
No, because I believe we are bound to treat it as a serious crime or crime of moral turpitude based on the elements of the crime.
Correct.
So I don't believe, and I don't believe it's anybody's position that we have authority to do any different.
Not
And
right.
so I'm wondering why we would take evidence on something we have no authority to act on.
Well, because I'm not asking you to do anything outside your authority. I'm not asking you to find that the criminal judgment was in error and it is void and of no effect as to her. It will be honored, unless it's set aside by the writ. But all we're here to do is show the circumstances surrounding the offense and other character testimony to try to convince this honorable tribunal to treat it only as a serious crime, not an intentional crime. So At no time, the actual innocence that Ms. Barron is asserting on her behalf is for another court, another time. The fact that she's done it simply goes to Ms. Barron's personal opinion about the facts of the case and the state of the law.
Does anybody else have any other questions before we start evidence? Go ahead and begin the evidence then.
May it please the board, take care of some of the practical matters. From the file, we filed our petition on May 14, 2008. The respondent's original answer was received on June 4, 2008. Respondent's first amended original answer was received June 7, 2008. The agreed interlocutory order suspension signed by BODA was filed June 19, 2008. A mandate issued by the Court of Appeals for the 4th District of Texas came on March 25, 2011. The motion for entry of judgment of disbarment was filed with BODA on May 5, 2011. And the respondent's response to motion for entry of judgment of disbarment was received on June 15, 2011. And I would offer Exhibit A.
Any objection to Exhibit A?
Which is a certificate of the mandate, and also Exhibit B, which is certificate of Blake Hawthorne, stating that Ms. Skelton is currently licensed, but not currently authorized to practice law.
No objection.
Exhibits A and B are admitted. Yes.
And with that, subject to any potential rebuttal witnesses, the commission would rest.
Mr. Lee?
I would first call Mr. Bob Hurley. Record, please.
Robert Lee Hurley,
And where do you reside, Mr. Hurley?
Pleasanton, Texas.
How are you employed, sir?
Self-employed on 2 small businesses.
What are those small businesses?
One is an auto parts store and the other is a movie theater.
Do you know Patty Skelton or Patricia Foster Skelton?
Known Patty since probably 1992.
And you were permitted to hear the oral argument, so you understand here that we're not trying to undo that criminal conviction, right?
Yes, sir.
Are you aware of that conviction?
Yes, sir.
Were you aware of the circumstances surrounding her arrest, indictment, trial, and all that?
Yes, sir. Not in great detail. I haven't read any of it, but I've been told about it verbally.
Now, my understanding from talking to you previously is you have some background in business which has exposed you to the conduct of a lot of lawyers. Is that true?
Yes, sir. I was telling you that in my career, the family business was the auto parts store. I grew up in Pleasanton, but then I went to college and then the military. And then I went to work for a national corporation, and at 31, I ran their Houston region for them, and I was there 12 years. When I left there, that's hence that I moved back to Pleasanton, and that's in due course I met Patty. That's why that year came up.
The auto parts chain, I think we've all heard it by its common name. Would you tell these folks?
Napa Auto Parts.
And how many people did you manage or supervise when you?
It was the Napa Distribution Center operation and the retail stores operation in Houston. And when I left, I believe it was 92 employees, and it's a $16 million house, and I had 78 independent customers and 11, if I remember correctly, retail stores in Houston that I was responsible for.
If you had to project, say, in an average month, how often would you have to speak to a lawyer representing your company's interests?
Well, I dealt with carpet lawyers frequently on leases and on the company retail operations. Occasionally, we had EEOC suits, TWC suits, and we had a reporting process for our carpet attorneys. So I dealt with the carpet attorneys quite a bit. Occasionally, I would have a customer. I think once or twice I had a customer sue us directly in Houston. So I had a local attorney that I dealt with who had a firm there, and so I dealt with them in those suits. So I would say no more than 2 or 3 times a year, maybe monthly, talking to corporate attorneys, and no more than 2 or 3 times a year in dealing with the local firm that handled some local matters for us. And also, my 78 independent customers, we operated in a great fashion as a business consultant to them. We had a very close relationship with they're not a franchisee, but they operate in a great deal like that, so we had a close relationship with them. So we not only did P&L analysis and banking relationship analysis and loan assistance, if they had a legal problem, we were available to help them. And if they didn't have an attorney, I would refer them to the people in Houston that I dealt with. A lot of times in small towns, local attorneys don't like to get embroiled in local issues. And so probably not more than that.
Check. I'm sorry. I think this is going on topic. It doesn't seem relevant to
I'm sorry.
our case.
If we could just speed up the process. I know you're trying to get some background, but
Well,
That's
what I'm asking you here to do is, do you feel that you've had enough experience in dealing with lawyers to have some rough idea of who's an ethical lawyer and who's not?
I'm sorry.
Checks and beating.
I can go back to the question I asked before.
Overruled. Go ahead and answer the question.
Certainly I have my opinions.
Do you have an opinion about Patty Skelton?
Well,
Do you have just yes or no? Do you have an opinion about her character as an attorney?
yes.
And what would you take into account in forming that opinion about Ms. Skelton's character as an attorney?
Services that I engaged her to do and that she performed for me as a lawyer.
Okay. How many different matters she represents you in?
2.
Okay. And she ever represent any family members or close friends?
She did in the about 96 or 97, she helped my parents redo their estate planning and their wills, and it was a very difficult time for them to deal with it, and she was very effective at working with them. I'll tell you, when the process was through, my parents loved Patty, and they helped us develop a plan that worked really well for us, and my parents are gone now, and we would have been in a lot of trouble estate-wise if we hadn't had this plan she worked out for us, and she was most effective in dealing with that. We were very pleased. I couldn't have asked for a better job.
Well, now you know she's been convicted of forgery regarding the will that she prepared and all that. Does that change your opinion about her effectiveness?
No, I've never known a more ethical or honest or caring person in my life, and I have to tell you that, and I say this with a lot of jeopardy in a room full of lawyers, I don't think there's a lot of good lawyers around. The ones I've dealt with, there's very few good ones that really care about their clients, in my experience. And she is one of those good ones who cares about her clients.
If the board does decide to merely suspend Patty so that when she completes her probation, her license is restored, would you entrust her with works for, say, are your parents still alive?
I entrust her with any needs that I had. Yes, sir.
Okay, thank you. I'll pass the witness.
Mr. Hurley, did you know that Ms. Skelton was also indicted in November of 2004 on charges of theft, money laundering, securing execution of a document by deception, and criminal conspiracy?
I would object
Did
to
you
the
know that?
relevance of this unless you can show she's been convicted of those matters.
Overruled.
I know there were a lot of trumped-up charges, in my opinion, that were thrown at her, and I call them trumped up simply because I know her personal integrity, and so I don't believe them. But I do know there were other charges, sir. I don't know what they all were, and I wasn't privy to all the detailed information.
Did you know that she told her client in that underlying case to go home and make it look like her son actually lived there when he didn't, in order to get homeowners insurance benefits when he passed away?
Objection leading, objection, no foundation, objection. I think it calls for hearsay.
He's offered character testimony, and he can answer whether he knew that or not, whether or not it's true. You don't take it as true. Go ahead
I
and
don't know
answer the
anything
question.
about that.
Did you know that the son in that case actually lived in his own apartment?
No, I don't know anything about that circumstance.
Did you know that Ms. Skelton forged her client's husband's signature in that case?
Not aware of that.
Did you know that Ms. Skelton had her secretary forge a notary's signature in that case so that Ms. Skelton and her client would get all the insurance proceeds?
I'm not aware of that.
Pass it.
All these things Mr. Velton asked me if you're aware of, do you believe any of those things are true?
No, sir, I don't. And I can only base it on what my opinion is of Patty and knowing her, her doing legal work for me, and also being a friend for years. I've never seen anything but high integrity and ethics in all of the actions I've ever had in all of my dealings with her, personally and professionally.
Well, let me ask you, are you aware that a lawyer could do something that was wrong, that was very beneficial to a client, but still wrong? Did Ms. Skelton ever suggest doing anything wrong that would benefit you or your parents in your dealings with her?
Ms. Skelton also handled the sale of a 1,000-acre tract that was in the family, that was in Tarpley, and that had been owned in our family for some 50 years. Therefore, all the titles were very complicated. And she dealt with great integrity with all of the neighboring people. She handled all of the deeds for me. She got a very complicated deal done, and everyone that dealt with her was pleased with her actions, thought highly of her. I can't imagine Patty intentionally breaking any laws like that. Maybe accidentally, maybe in a zeal to help a client, I don't know. But not intentionally, no. She would never commit anything like that, in my personal view.
Thank you. Pass the witness.
Did you know that Ms. Skelton, as county attorney, would frequently sit down with the JP and decide what would happen to out-of-town ticket receivers in their criminal cases?
No, sir, I don't know anything about her functions, except that I knew she was county attorney for a short period of time, but I don't ever recall having any detailed conversations with about what she did in that job.
Have you heard that she frequently uses racial epithets?
I have never heard Patty do that.
That's
Never.
We have no further questions.
Okay, call your next witness.
Call Mr. Tom Harwood.
Harwood, Mr. Lee? Is that right?
Yes, Tom Harwood.
Raise your hand. Do you solemnly swear or affirm the testimony you give the truth, the whole truth, so help you God?
I do.
Would you state your name for the record, sir?
Tom Harwood, Thomas A. Harwood.
And how are you employed, Mr. Harwood?
I'm a lawyer.
How long have you been lawyering?
Too long. 48 years.
Only 48? I don't know how you can make a judgment about that in such a short period of time. Where do you practice law?
Beg your pardon?
Where do you practice law?
Valley, Texas.
Okay. And I believe you know that Ms. Skelton used to practice in Pleasanton, is that correct?
Far as I know.
And then remarried and moved over to Real County, correct?
Well, I don't have any actual knowledge of that. I first saw Patty, of course, county attorney in Real County.
Okay. And then, well, let me ask you your background, your experience. What kind of law have you practiced and where in your 48 years, briefly?
Well, I've just done all kinds of office practice, but mainly I do trial work.
Where did you start practicing law?
Dallas, Texas.
And how long did you practice there?
8 years.
Associated with any firms we'd have heard of?
No, I had my own firm started. My own as soon as I got out of law school.
And from Dallas, where'd you go?
San Marcos.
What did you do in San Marcos?
Well, I was practicing law full-time. I was elected to be county judge by the Bar Association, constitutional county judge. I had an oil and gas retail and wholesale business.
Okay. And then how long did you stay? How long were you county judge?
About 2.5 years. The sitting county judge had just started a heart attack, and the bar needed to get somebody in to handle probate matters because of title. And so the Bar Association elected me every 3 months is what I'm going to do.
Okay. And then how did you end up, where are you now?
Uvalde.
How did you end up there?
I beg your pardon?
How did you end up there, sir?
I bought out a lawyer's practice by the name of Taylor Nichols, who's a very fine lawyer, and he wanted to get out of the business. I went there in 1984 in March, and I've been there ever since.
Okay. In your practice, have you had any experience with the probating of wills?
Yes.
How would you characterize your experience?
Well, I've done several probates, of course, over the years, including probating copies of the wills. I don't know how many I acted on as county judge, but numerous.
Do you consider yourself to be reasonably familiar with the probate code as relates to the definition of a copy of a will?
I think so. There's some pretty good body of case law now.
Okay. Sir, I have these exhibits that are A, B, and C, and Mr. Veltman's are also A and B. Would you like me to have them remarked, such as respondents A, B,
Just
and C?
RA. Put an R in front of the first letter.
Could you please mark these as R, A, R, B, and R, C, maybe? Mr. Harwood, I represent you that these are all taken from your files. Will you look at them and see if you recognize them if they're your copies?
Exhibit RA is a fourth amended original petition filed by Rogelio Munoz representing the contestants in the will, civil case.
And I believe you've explained to me that Mr. Munoz misnumbered the fifth amendment. Is that true?
Well, he filed it, the third amended petition, improperly as a second amended petition, I believe. I don't know how many there were amendments, but this was the one he went to trial on, as far as I know.
Okay,
That
thanks.
was his active pleadings.
So that was his live pleading time of trial.
Yes, as far as I can know.
And document RB.
RB is prepared by myself, and This was served on February the 17th, 2009. I think that's my active pleading. I don't want to call it.
And RC.
RC is the charge of the court. In the civil case prepared by Judge Evans and the counsel.
And this is the case you tried, and you recognize all these documents?
Yes.
And you offer respondents R, A, RB, and RC.
Objection as an improper collateral attack on the underlying criminal judgment.
I'm going to go ahead and admit them and withhold ruling on the objection. I understand the objection. I have concerns about them. We'll go ahead and take the exhibits. I will say that if any testimony, we really don't want to hear much testimony on the anything that would be an attack on the judgment, the criminal case.
Okay.
But we'll go ahead and admit those without ruling on the objection, hold the objection.
Can I also inquire as to whether original certified copies were submitted to the board?
They were not.
I would object on that ground too.
On authentication.
Correct.
Okay. We'll also go ahead and admit it subject to the objections.
These documents you've looked at, what case do they involve, sir?
I'm sorry?
These documents you've looked at and identified as being true copies.
Absolutely. I have personal knowledge of them.
Yes. Well, what case do they relate to?
It was a will contest case?
Yes.
Yes. That's what it was.
Whose will was it?
It was of the deceased, the Canales, I forget his first name, but his executive that was appointed in the probate was Robert Canales, Jr. The deceased was his uncle.
Who is your client?
Robert Canales, Jr. is the executor of the will.
And this will that was at the subject of this contest, is this the will that Patty Skelton prepared?
As far as I know, yes.
Is this the one that she was charged with and convicted of forging?
Yes, I testified in that case.
Okay. And I take it that without regard to the judgment in that case and its finality, your opinion was that will was a valid copy.
Objection,
correct?
Leading, and also objection. The question calls a witness to usurp the role of the trier of law in this. Well, not only the trier of law in this case, the board, but also the jury in the underlying criminal case.
I don't know how this. Obviously, I'm not articulating this correctly. We are not trying to prove that the judgment in the criminal case is void or invalid or subject to collateral attack in this proceeding. Merely going at what another jury looking at the same documents came up with, getting to the issue of how serious was the conduct that led to the conviction. The conviction stands. It's not going. Nothing we can do today will change that. Nothing will change her status as a person on probation. We're looking at the context of what kind of person is on probation.
Well, as I read Rule 802, it says that the record of conviction is conclusive
Correct.
evidence.
Correct.
Asking him whether it was a forgery or not when there is conclusive evidence that there was seems to be irrelevant.
Well, I was asking the question because he defended the will at a contest, and he had to come up with a legal argument to make the argument that the will was a valid copy, and it was ultimately, as shown in Exhibit C.
As I recall, your question was what his opinion was about the forgery.
Yes.
And there is conclusive evidence that it was a forgery.
Well, it would seem to me in the context of a hearing like this, he is entitled to have an opinion of whatever it is. The prosecution went off track or whatever. It doesn't change the fact that she's convicted. It's just context for his activity as a lawyer in a companion case, trying to, and successfully, upholding the validity of this will copy.
In that case, the witness had not been designated.
And I wasn't served with anything, any discovery. There's no requirement that I know of in these rules that I designate an expert if not asked to designate.
Are you designating him as an expert on legal issues, though? I mean, we've got lawyers to decide the questions of law.
Or I think he'd have to be designated as a handwriting expert. I mean, there's no evidence to have him admitted as a handwriting expert.
Well, I don't know why I would want a handwriting expert.
Didn't have any designated anything to attend testify on questions of law.
I mean, she testified at the criminal trial as to how this copy was created, and you'll hear from her later.
But you know, and I know you've said this several times, I'm really struggling with the issue that you've got an underlying criminal conviction, and we're talking about the facts of that conviction. And I understand that there's somewhere in the gray area you're talking about the intent, so you have serious versus intentional. But having him testify as to anything about the underlying facts, I don't know what the purpose of that is. I mean, and maybe I just need to be educated, but I don't see why his testimony about the nature of the offense, the facts surrounding that circumstance, are relevant in any way. What I think you're trying to say is that her mindset was something X as opposed to Y, serious as opposed to intentional. But I'm not sure what he can testify about that, and certainly, despite his 48 years of practice, I'm not sure what his experience as a lawyer brings to bear on that question. I just don't see it.
I can only say then the problem must be that I'm not articulating it very clearly, because it seems to be a uniform problem. But I've never had a case such as this, where someone's been convicted of a crime, which requires the intent to deceive in the alteration of a document, and then later have the document in another court be held to be a perfectly valid copy. And I think that's relevant to deciding whether she should be suspended or disbarred.
You can ask us to take notice of the verdict in the underlying case. You can ask us to do that. So why do we need all of this other evidence of everything else that was going on when you can ask us? It sounds like what you're pointing to here is the fact that there were inconsistent jury verdicts in the two cases. So why don't you just ask us to take notice of that versus have all this other evidence that all of us are struggling with how on earth it's relevant?
Then I will accept that suggestion and accept the idea that my notion of relevance in this seems to be incorrect, and I will pass this witness. And I will ask you to take judicial notice of Exhibit RC, which is the verdict of the jury. And I was just trying to establish with him it's the same will. I mean, do we take that for granted that the will in these documents is in fact the will that she got convicted on, or do I need to prove that?
Is there any objection to that? These are the two same incidents. It's subject to your objections.
I have an additional objection then to
Okay.
the exhibits, and based on the fact that it is a civil case and the standard or the requirements for that are preponderance of the evidence versus the criminal case, which was beyond a reasonable doubt. The issues at stake in that case were very different witnesses. I don't see that it's appropriate for that case to act as a collateral attack on the criminal judgment, which is the only purpose that it could be brought in for at this point. If he wants to have testimony as to her state of mind or the acts that were taken by Ms. Skelton in the underlying criminal case, this is not the appropriate way to bring that sort of evidence in.
But we're not saying that we're dealing with two different documents.
Yeah, that's what I say. As a threshold
really
matter,
what the
it's the
question
same
is.
will.
It's the same document.
Mr. Veltman, is there any, perhaps this way, is there any dispute on your part that the documents at issue in the two cases are the same?
The will?
Yes, sir.
I do not know because I was not there, but I am assuming that I do know that the forum and the presentation of that case and the document is completely different in a civil case versus a criminal.
Yeah,
Let's accept that difference. Our only question is, are we dealing with the two documents?
Right. We're just trying to find out if there's a dispute of fact here. We're going to argue, a long time, it sounds like, about the significance and relevance and all that. But is there really any dispute that we're talking about the same things?
I have no knowledge on that.
And if I could be indulged in a little leading, let's get that covered right now. Mr. Harwood, you testified in the criminal trial, is that correct?
Correct.
You were the lead lawyer. You were the only lawyer for the executor in the will contest.
I was designated as an expert in probate law.
Okay. In the criminal case.
In the criminal case, the Judge Schubel was the presiding judge of that. He was still the judge in the civil case before he died that I was trying.
Now, the will. Are these two different copies of the same will? Are they the exact same pages that were the subject of the criminal case and the civil will contest? If you know. Do you know?
Yes, I know.
Were there two different will copies? 3, 4, 5?
Not to my understanding, there was a copy of a will that was filed by Patricia Skelton, designating it as a copy in the probate application.
Correct.
And it was also alleged in that probate application that the original will could not be found after a diligent search.
Yes.
Objection as to hearsay.
Mr. Harwood, let me just say, is it the same will that was the subject of the criminal matter, the subject of the civil matter?
Let me explain this. I practiced criminal law in my earlier career, and it's rare to see a case that's a criminal case and a civil case that is identical in the issue to be determined. I don't know, he mentioned that there's two different standards of proof. That's correct. But if I want a civil jury on that identical issue that was submitted in the criminal case as to fraud or forgery.
Objection non-responsive.
All we want to know is it the same will in both cases?
Absolutely.
Okay. Are you
The will was upheld as a valid copy in the minute of probate, correct?
Mr. Lee, are you asking us to take judicial notice of the ruling and verdict in the civil matter?
I did, yes.
Okay.
RC.
Subject to Mr. Veltman's objections, and I won't. There were several, and we'll go back to his first objection all the way through. And without saying that, ruling on those objections, we'll go ahead and take judicial notice of that, subject to the objections, and withhold ruling on for the time being.
The verdict that's reflected by Exhibit C, was it reduced to a judgment?
Yes.
Was that judgment appealed?
No.
Is that matter final now?
As far as I know, the mandate came down. It didn't have a mandate because it never went to the Court of Appeals.
Okay. That's witness.
No questions.
Call Ms. Lucinda Vickers.
Yes, I do.
Hello, Ms. Vickers. Would you state your name for the record?
Lucinda A. Vickers.
And what do you do for a living?
I'm an attorney.
How long have you been licensed?
I was licensed in May of 1985.
And how are you currently employed?
I have two jobs. I've had a private practice in Pleasanton, doing civil and criminal work starting in probably about 87, 88. And on January 1 of 2009, I took office as county attorney of Atascosa County. And in that county, they consider the county attorney job, although I have two assistants, to be part-time. So I'm allowed to keep my private practice, so I continue in that also.
Okay. And how do you know Patty Skelton? What do you do?
I met Patty when she moved to Pleasanton. She married a man that was from Pleasanton and grown up there, and they moved there. This was, I think, probably before my daughter was born, 1990, something like that. And we were two young female lawyers in a small town. That didn't happen very often, so we became very good friends.
Okay, so have you observed her practicing law?
Oh, yes. We actually had some cases against each other on occasion.
Okay. Are you familiar with the circumstances that bring us here? The will, the controversy about
Yes.
its authenticity, the two resulting trials?
Yes, I'm familiar with the information regarding that.
And have you followed that as it's progressed along?
Yes, I have followed it to some degree, yes.
We'll all assume you're here to give positive character testimony from Ms. Skelton, so I'll ask you, before you do that, is there anything about what occurred in either the criminal trial or the civil will contest that negatively impacted your opinion?
Not one single thing.
Why not?
Because I've known Patty for a long time. We've been very good friends. We shared a lot of things together, and she would never, ever do anything that I would consider to amount to a crime, ever.
Okay, but you do know she's been convicted of a crime.
I understand that. I'm a was a criminal defense lawyer, and I'm now a prosecutor. I understand exactly what you're saying.
Okay. So the fact that she's on probation now, that doesn't give you a problem with vouching for her?
Not one.
Okay.
No.
Now, what this board is concerned with is what the right thing to do to protect the public is, whether she should be disbarred or whether she should be suspended during the time that she serves her probationary sentence, subject to being disbarred if she busts probation and gets revoked. Do you understand that?
Yes, I do.
Can you explain to them why you think that the sanction of suspension is what's appropriate in this matter?
Objection, leading.
Overruled. We assume that's why you're here.
You'll have to excuse me. I'm suffering from a cold. I'm losing my voice. I mean, I have my own personal opinion about the conviction. I will tell you that there is absolutely no reason to disbar Patty Skelton. There isn't any. I would hire her right now. She had a valid law license in my office, regardless of any of these facts, regardless of this conviction. I would hire her at my county attorney's office. I have no problems whatsoever with any of her actions, and I would trust her implicitly.
When you agreed to, or as I understand, sort of volunteered to come testify on her behalf, did it concern you that as a person involved in the prosecution of the criminal laws of the state of Texas, there might be a negative appearance on you coming and speaking on behalf of a person who's been convicted of a crime?
You know, I've been practicing law a long time, and some people might have that opinion, but I do what I think is right, and that is what I think is right. And the fact that I'm a prosecutor and may prosecute cases, I have what I have ultimately discovered is a rather peculiar notion about prosecuting criminal cases. And I'm not naive about things that occur in criminal cases and in jury trials. But I have absolutely no concern. If somebody wants to be upset with me for doing that because I did what I thought was right, then that's going to be their problem.
Okay. I'll pass the witness.
Ms. Skelton was the county attorney at the time she was indicted, right?
I don't know that she was still county attorney at that time.
She was previously county attorney, though? Did you know her
She
at
was,
that time?
yes, I knew she was county attorney for a period of time, and yes.
Did you know she was also indicted on another case, November 2004, involving theft, money laundering, securing execution of a document by deception, and criminal conspiracy separate from the underlying criminal case in this
Well,
case?
that's a fairly standard thing to do when you're a prosecutor, is to indict somebody for everything you can think of, so it wouldn't surprise me a bit.
Did you know that she told her client in that underlying case to go home and make it look like her son was actually living there so that she would get insurance proceeds from a homeowner's insurance policy?
I am not aware that that was a statement that was made about her. It's hard to know something when you don't think it's true. All right?
Have you heard her son actually lived in his own apartment?
I know nothing about any of those statements. No, sir.
Have you heard that Ms. Skelton forged the husband's signature in that case?
I have not heard that, no.
Did you know that she had her secretary forge a notary signature in that case so that Ms. Skelton and her client would get all the insurance proceeds?
Again, as I said, I don't know any of those facts. I find it hard to believe and don't believe that that's so I haven't heard it, no.
Have you heard that she commonly sat down with the local JP to work out tickets from out-of-county drivers?
I've never heard anything like that, but county attorneys often talk to JPs, as I well know, especially in small communities.
Pass it.
Have you ever heard that the prosecution of Patty Skelton was motivated by anything but the desire to properly enforce the criminal laws of the state of Texas?
I have heard rumors to that effect, yes.
Do you believe it's possible that such a thing could happen in the state of Texas?
Yes, I have seen witch hunts before in my life, and I believe it's possible that that can happen.
I had a question, but I failed to write it down.
Glad I never do that.
I'll pass the witness.
No further question.
Any questions by the board? Ms. Biggers? Thank you. I'll call your next witness.
I'll call Ms. Nancy Barron.
I do.
Ms. Barron, would you state your name for the record?
My name is Nancy Barron.
How are you employed, Ms. Barron?
I am a self-employed attorney.
How long have you been licensed?
I want to say this is my 31st year.
Okay. And where do you practice?
I practice in San Antonio.
Okay. Do you hold any certifications of special competence?
Well, I'm board certified in criminal law. I'm admitted to the bar, Texas, Missouri, a number of federal circuit courts of appeal in the United States Supreme Court.
Okay. Just briefly, how do you know Patty Skelton?
Patty Skelton is a client of mine.
For what purpose?
I was retained by Ms. Skelton to prepare her direct appeal. And then as of yesterday, I filed an application for a post-conviction writ in her case in the district court in Real County to vacate and set aside her forgery conviction.
Okay. The appeal was not successful, was it?
The appeal was not successful.
What's the basis? Why are you asserting writ of habeas corpus?
Well,
Objection as a collateral attack on the underlying criminal judgment.
Yeah, I'm not sure. I fail to see the relevance of this if it's not going to the underlying criminal judgment.
Well, I'm just trying to establish that this lawyer, a lawyer of great experience, this is an unusual process and that she believes enough in this process that she's making the assertion of actual innocence. That's as far as it goes. Just so that this court will know, I couldn't have offered that into evidence because on the deadline that Mr. Veltman and I agreed to the exchange of exhibits, this thing didn't exist. It was filed yesterday. That's all. I'm not even going to offer it.
Okay. For that limited purpose, go ahead and answer the question.
And I'll wrap it up by leading. Are you asserting at all actual innocence in this writ?
that is one of the grounds that I'm asserting.
Okay. And how often in your career have you asserted actual innocence in a writ?
This would be the first time.
Okay. You believe you have the experience to, if this is your first time, to recognize what the legal standards would be, to even assert that in a non-frivolous manner?
Yes.
Okay. And is it your testimony to these good folks here that you have filed this with the district clerk and intend to have it heard and decided?
I filed it, yesterday by registered return receipt mail. I do have the documents here, timely when filed, and served a registered copy on the district attorney for the 38th district.
I'll pass the witness.
No question.
Anybody on the board have questions?
Question? Did the proceeding today affect the timing of when you filed that yesterday?
I'm sorry, could you, I'm just,
Did the proceedings today impact your decision to file that, habeas yesterday?
if I could just briefly respond to that, my ability to file this at all jurisdictionally required that I wait until after the mandate issued from the direct appeal, which I believe was March 25th of 2011, as part of my obligation in filing this writ, and I've been working on it for quite some period of time. It was necessary for me to get a transcript of the will contest trial, which is part of the exhibits in that case. It was very difficult to find the court reporter who actually reported the will contest case. And after much looking, I located her in College Station, Texas. And then it required me to obtain some money from Ms. Skelton's father to purchase the record, and then I had to take my place in line before I could receive the transcript. So I read the transcript last weekend, and so then I included in this writ application a recitation of the evidence there, and I do have certified copies in my supporting exhibits.
And my question goes to the timing, why it was yesterday versus next week or a week from now. Did you file it yesterday because of this proceeding today?
Well, yes, I would say that I hurried it up to finish it, but I had done the primary amount of work probably a couple months ago. But I was waiting on the will contest record.
Thank you.
On the direct appeal, was that to the was that to the Court of Appeals or the Court of Criminal Appeals?
It was to the Fourth Court of Appeals.
Fourth Court of Appeals. Did the Court of Criminal Appeals have any further jurisdiction over?
I filed a petition for a discretionary review there, which was denied.
It was denied. Okay.
But if I might add,
Please.
the record that I had to work from is every single issue was waived, and so it was. There was only one issue that was not waived, and only because that cannot be waived as a matter of law.
Any other questions? Redirector Cross?
Yes, sir.
Thank you.
I'll
Next.
call Patty Skelton. Would you state your name for the record, ma'am?
My name is Patricia Skelton.
And you've heard all this. This is you we're talking about, right?
It's me.
Okay. Well, and you've heard the nice things people have said about you. And you've heard that there are apparently people who've said some things, or at least said to Mr. Veltman, that he's asked people about. These folks now have to decide what the appropriate thing to protect the public would be regarding you. So first let me ask you, if they were to suspend your license and you finish serving a probationary term, do you have any interest or desire in practicing law again?
I think I would like to practice law again, very much so.
Why? What would motivate you to practice law?
It was something I enjoyed, and I am asked at least several times a week by clients and friends when I'm going to get my license back. And we don't have my license back because they want me to do things for them, and at this point I can't.
Okay. Did you testify at your own criminal trial?
I did.
Okay, so the conduct involved, how the will copy came into existence, that was all discussed.
Yes.
And these people know that you were found to have committed the crime of forgery.
Yes.
Okay. Well, let's just describe that. Well, no, I'll just... Is there any doubt in your mind that the document that you presented to the court did anything but reflect the donative intent of Isidro Canales?
No, there's no doubt at all in my mind.
And was it your desire or goal in any regard to benefit one heir over others or to cheat anyone out of an inheritance or birthright?
No, I had no desire like that.
There's been some commentary, Mr. Veltman's indicated that you might have engaged in racist speech.
Yes, I heard that before at the trial.
Did you admit it was true then?
No.
Do you admit it's true now?
No.
Did you hold any racial animus toward any of the participants to that proceeding, either the creation of the will or the will contest?
The proponent of the will, the nephew of the decedent, was Hispanic. He had been my client. And a lot of his relatives, some of whom were contestants, had also been my clients in years past. There had never been any claim that I was a racist at that time. And it was not until the trial that that actually came up. And it came up as a motive for what I did because they couldn't find any kind of monetary or other motive.
Did you all feel any sense of vindication when the copy was upheld in the will contest?
Absolutely.
I guess the question I would have, or I would like you to elaborate on, is having been through what you've been, and you will unless that writ's successful, always have the stain on your record of having been convicted of forgery. Do you think that you can uphold the trust of the public under those circumstances?
I'm sure that there are some people that will want to believe the worst. But for the most part, what I have encountered in my experiences in my community is that people did not believe what was written about me in the local newspapers or what some of the witnesses testified about. And were actually appalled that this case went as far as it did.
Now, up until the time that this problem broke out, were you ever called upon to act in the role of client?
Not that I can recall.
Would you recount to these folks what, if anything, having to be a client rather than the advocate over the last 7 years has taught you that might make you a better lawyer?
I've been a client. I think I have had attorneys in 4 different capacities, 4 different kinds of attorneys, including you. And it's been an eye-opener for me to be sitting on that side of the desk for a change.
How so?
I think, if anything, it's probably made me more able to empathize with the plight of people who are having to hire a lawyer.
Well, what I've heard from Ms. Vickers, both on and off the record, and Mr. Hurley, I never thought of empathy as being one of your problems. Do you feel that in some regard you are not giving your clients as much before as you would give them now?
I think I would probably be more inclined to listen to everything they say instead of just answers to the questions that I'm putting out to them.
And do you think that you could make a commitment today, yes or no, that if you were allowed to practice law, that you would strive to uphold the standards of the, not only the penal code, but the Texas Customary Rules of Professional Conduct, and just general good morals and good character?
Yes,
Okay,
without
thank
a
you.
doubt.
I'll pass it on.
Skelton, are you guilty of forging the will of Isidro Canales?
I was found guilty in December of 2007 in Valdez County of that very thing.
Did you file with a court a will purporting to be the last will and testament of Isidro Canales?
I filed a copy with that court purporting to be a copy of his last will and testament.
Did you cut and paste Isidro Canales' signature on that will?
I did cut and paste 1 or 2 signatures. I would have to see if that was one that I pasted. I don't remember.
Did you cut and paste the signatures of the
Your Honor, I
two
don't
witnesses?
think he's going into the very topic that he's objecting to the relevance on. If we want to let him go into this, I think that'd be fine if Mr. Harwood can come back and explain the law of copies and whether cut and paste is any impropriety under the probate code and that sort of thing.
This all goes to the respondent's ability to take responsibility for her actions, which is a Philippa factor. It's not whether she was found guilty or not.
But I avoided asking you these questions. You saw me stop. I didn't try to relitigate how this copy came into existence, her thought processes about it and all that. I'm willing to go into it if I can go into it with my witnesses too.
Again, I believe this is completely separate. It deals with ability to take responsibility for actions. It sounds like she is contesting whether she was really guilty. She has stated that she felt vindicated by the civil will contest. So I think it's valid for us to go into her attitude about whether she's guilty or not.
And may I, sir? If she had pleaded guilty to this and was coming here claiming I didn't do it, I'd have a big problem with that and I wouldn't do it and he should attack her. But she's professed her innocence throughout. She's been vindicated in the will contest. She's pursuing a writ of actual innocence. To have her now expect her to say, yeah, I'm guilty, is ridiculous. And there was not anything that would go toward her acceptance of responsibility. She's accepted responsibility by entering into an agreed interlocutory order during the appeal, going through this process appropriately.
Let me tell you what we're going to do.
Okay.
Okay. Mr. Veltman, If you go into this line of questioning, I'm going to allow him to reopen with his witness and examine the current witness on the subject matter of the underlying litigation. So
I understand. Ms. Skelton, you were also indicted in November of 2004 for charges of theft, money laundering, securing, execution of a document by deception, and criminal conspiracy, correct?
That is absolutely correct. I was.
And that was in regard to a case involving insurance, right?
It was an insurance settlement.
And that client that was involved in that case was a Deborah Harding?
Yes.
And she came to you, why?
She and her husband and her ex-husband, the child's biological father, all came to me at the same time to hire me to pursue some sort of settlement or lawsuit, whatever, for the boy's death.
Are you saying that you met the ex-husband personally?
I certainly did.
So, you told the wife, which is Miss Harding, to go home and make her house look as if the son had lived there, correct?
No, that is absolutely not correct.
And the issue was whether they could get homeowners insurance coverage for his death depended on him living there, correct?
No, that's also not correct. The law was completely different than that at the time. The law just required that he have an intent to return, and that he had lived there with an intent to return at some point, which was not a problem because that was the truth.
Isn't it true that you told your secretary to notarize the signature of the ex-husband?
No, that is not true.
Isn't it true that you asked her to file that document with court?
Which document are you referring to?
The document containing the ex-husband's signature that would allow you and Miss Harding to receive the funds.
I'm not aware that that document was filed with the court at all.
Wasn't there a document in which the ex-husband was purported to sign over the insurance proceeds?
It was a release, but it was never filed with a court. There was no court proceeding in this case for it to be filed with.
So you're saying to us today that you personally met with the ex-husband and had him sign that release?
No, I did not. If I may, I'll back up. When I met with the ex-husband was shortly after the boy's death. That was in the year 2000, in the fall of 2000. And if I'm not mistaken, he had come to town for the purpose of the boy's funeral. He did sign a document at that time. I think it was an assignment that he signed at that time.
So you witnessed that?
I saw it being signed and my secretary notarized it.
Which secretary was that?
I believe that was Amy Wimberly. Was working for me at that time.
Amy Wimberly is not the name on that document as a notary for that signature,
She
right?
was a notary on this assignment document.
But the release was not
The
signed by
release
Amy.
was
then.
done nearly 2 years later.
I want to pass the witness.
Mr. Lee?
One second. We're listening to among the people here supporting you. I met your husband, Wiley. He's been with you throughout this, right?
Yes, he has.
How's he employed?
He is a veterinarian.
And despite all that's gone on, despite the various accusations, acrimony, claims of bad motive on your part, county attorney's part, whoever else's, is it your intention to remain there in that county with Wiley?
Yes. And we have this entire time, nearly 8 years.
Why, in light of all that's going on, do you have this commitment to remaining in Real County and practicing law?
I have been asked that by other people, why are you there, why, I would have left that type of thing. But I like most of the people there, with some exceptions. I like the feeling of being able to help them most of the time, and I got a great sense of reward from that.
Thank you. I'll pass the witness.
I have a couple of questions. I'm sure others may well. I'm not sure exactly what the transaction was that you're testifying about, a client that had signed a document that you witnessed. Do you recall that testimony? The gentleman that signed the document.
I'm confused which case we're talking about because there were two different cases.
It was the earlier case on the insurance claim.
The insurance claim case, okay.
Yes, ma'am. Do you recall that?
Yes.
And then you said that your secretary notarized that signature. Is that right?
There are two different documents, I think, that are getting confused here. One was an early document. It was an assignment of interest, and my secretary notarized that. And
Okay.
I was present at that time.
Did your secretary witness the signature?
She notarized it, and she saw it happen.
She did witness the
She didn't
signature?
sign as a witness. She signed as a notary.
Okay. She did witness the signature? She did see him sign it?
Yes.
Okay.
On that earlier first document.
Can I ask a couple more questions?
Let me see if other people have questions
I'm
first.
sorry. I apologize, sir.
Yeah. Yes.
I have a question. Yeah, my question is, there's been a lot of allusion to indictment, but I've never heard conviction. What happened on that insurance issue?
It was dismissed. In August of 2010, all 4 charges were dismissed.
Okay, with or without prejudice, or do you know?
I don't know.
Okay, but nothing else has happened on it since then, and they've been
No, and I
completed?
think maybe the statute of limitations has run on that because the indictment was issued in 2004. Dismissal was in 2010.
Thank you. That's the only question I have.
I have a question.
So,
Yes. The conditions of the community supervision that were entered on July 11th, 2008 have a 2-year period of probation. Have you fulfilled your probation?
My probation actually was, abated when the notice of appeal was filed. So originally, I only served 20 days of probation prior to the notice of appeal being filed. Until then, the mandate was issued again this March. So I'm currently under community supervision and have completed, a little over 6 months, 7 months, something like that.
Thank you.
other questions? Mr. Lee?
I apologize. Ms. Sheridan asked the question. I was going to ask just to establish those indictments had been dismissed, and I was asking Mr. Galvan, who was involved, whether all those matters are now barred by limitations, and he's consulting with Ms. Barron. But as of this time, she's in no jeopardy of any further criminal prosecution that we're aware of.
Okay.
Is that correct, Bob?
That's correct.
Okay.
Mr. Veltman, any further questions?
No.
Anybody else? Thank you, Ms. Skelton.
Respond to the rest.
Anything further, Mr. Veltman, or do you close?
No, I do have several rebuttal witnesses. If the board will allow.
Okay. Mr. Veltman, I believe we left off with you about to call a witness.
I would like to call Julie Becker, please.
Please proceed.
Would you please state your name for the record?
Julie Corley Becker.
Becker, did you work for Patricia Skelton?
I did.
How did you work for her?
I was the legal secretary.
About how long did you work for her?
I think about 2 years, 01, 02.
Are you aware of instances in which Ms. Skelton may have done something unethical?
Yes.
Did Ms. Skelton ever mention something about a car accident case involving a client's son and homeowner's insurance?
Yes.
And who is Debbie Harden or Debbie Roach?
She was one of Patty's clients.
Do you know why she became Ms. Skelton's client?
She had a son that was killed in a car accident.
And why did she come to Ms. Skelton, if you know?
I do. It was regarding a homeowner's policy insurance that I believe they were going to claim that he was a resident of their home.
And what did Ms. Skelton do in regard to that case and Ms. Harden?
That I have knowledge of?
That you have knowledge of?
Several things.
Go ahead.
The points of interest, I believe, are that I witnessed Ms. Skelton tell Mrs. Harding in front of my desk that in order to facilitate the payout from this insurance company, that she needed to go home, get clothing from Timothy's current residence, place it at her home, and take personal belongings and make it appear as though he was currently residing at that home.
Why was that important?
I believe at the time the insurance adjuster was going to come out and visit with them regarding the payout, and they wanted it to appear that he was still a resident of that home.
And what else did she do?
In regard to that case?
Yes. Did she ask you to file an affidavit from the husband?
She did, I do not believe, asked me to file it. I believe what she asked me to do, in fact, I know what she asked me to do was notarize a signature that I did not witness with an illegal or unknown name to me.
Do you know whether the husband signed that document?
I do not. She took the document along with Ms. Harding and walked outside, came back in, and it was signed and told me to notarize it.
So do you know whether Ms. Skelton or Ms. Harding signed it?
I did not witness either of them signing it, but they were the only two people that were in the context of that time frame.
Was it signed prior to them going outside?
No.
And when she asked you to sign as a notary, did you do that?
I did.
Did you sign using your own notary stamp?
The document in question, no, I did not. She gave me a name that she told me was a client in Atascosa County. This has been a long time, so I want to say Kanetta Williams, I believe was the name. She had me practice it several times and then sign it to the document. And I took an older notary seal, the kind that emboss, that don't actually have a name on it, that just raise the paper and attach that to the document.
What was the purpose of that document?
I believe it was a release. It had something to do with the insurance company paying the money.
Do you know whether she eventually got money from the insurance company?
Yes, I deposited that.
And the money, was that made out, or the check, was that made out to Ms. Skelton?
I believe it was made out to several, but I don't recall all the names that were on it. That might have been what it was. That's what it was. Mr. Roach's name was on the check, so I believe that it was a documentation that was necessary to deposit the check, I think. It's been 10 years.
Were you required to testify in regard to that case?
Yes, sir.
Do you know what happened to that case eventually?
I approached the new county attorney, district attorney, regarding those cases, and he told me that because Mrs. Skelton had been convicted in the forgery case, he did not feel the need to continue prosecuting the additional cases.
That's hearsay.
Sustained.
I pass the witness.
Ladies and gentlemen of the panel, I'm Bob Galvan. I practice law out in this area where this all occurred. I believe now for 25 years. I've had a ranch out there. I also have a home here in Austin, and I...
Mr. Galvan, are you testifying, or are you going to examine the...
Introducing myself.
Okay, go ahead and examine the
Thank
witness.
Okay, now, your name used to be Corley, is that right?
Yes.
And it's Miss Becker now? Is that
Yes.
Miss Becker. Miss Becker, at the time that this event occurred and that you came in, and we did have a proceeding where you testified in the past as part of the trial leading up to the will contest, isn't that correct?
The criminal prosecution, yes, sir.
Ma'am. Now, during that time period, there was, it's fair to say, extreme animosity between your family and Miss Skelton's family, isn't that correct?
I wouldn't say extreme, no, sir.
You wouldn't say extreme?
No, sir.
You wouldn't say a lot of animosity on your part and on your family's part against Miss Skelton and her son? You don't recall that now?
Yes, sir, I do. I see no relevance, but yes, sir.
Thank you. Okay. So when you did come forward with this information, you were, it's fair to say that you were extremely prejudiced against Miss Skelton and her family, isn't that fair to say?
No, I received a phone call from a Texas Ranger that said, come forth.
Okay. Now, when and this Texas Ranger came forth, how did he know to contact you to begin with?
I don't know that. You would have to ask him.
Okay. Now, what he confronted you with, isn't it true, was the fact that you had committed a crime. Isn't that fair to say? If these acts
Yes, sir.
consist of a crime, then you committed a crime. Isn't that fair to say?
Yes, sir.
And how long were you employed by Miss Skelton?
I believe it was 2 years.
2 years. But prior to that, you'd had extensive office experience. You'd been working in offices since you were, what, about 18?
Yes, sir.
Is that fair to say? Can you name those places where you had worked?
No, sir.
You can't remember.
I can remember some of them, yes, sir.
Okay, well, let's go with you over what you can remember. Let's start out when you were 18.
Objection as to relevance.
I think not, Your
He's
Honor.
harassing the witness, too.
How is it relevant?
Well, Your Honor, Ms. Becker has described these events where she affixed a notary seal onto a document, and somehow she's turning around now and saying that Ms. Skelton told her to do this. You know, what I'm going to bring out are facts that Ms. Becker knew exactly what she was doing. She did it on her own. The only person to say to the contrary is Ms. Becker.
You may ask her that. I don't
But
see
she was
her work history as connecting to that.
I think it is relevant, Your Honor, because she had, she completely understood what she was doing when she affixed this notary seal.
Objection as
So
to
she cannot.
the counsel testify.
Yeah, I'm going to sustain the objection as to her background. You can ask her if she knew what she was doing.
Okay. Now, you had your own desk in Ms. Skelton's office, isn't that correct?
Yes.
Okay. And at that desk and surrounding you, you had, all the items you needed to perform this act. And if it was a crime, to commit this crime. Isn't that correct?
Yes.
And through all of these proceedings, the only reason that anybody is saying that Ms. Skelton is guilty of anything here is because you say that Ms. Skelton told you to do it. Isn't that correct?
I wouldn't know. I don't know what the grand jury listened to when they indicted her on 4 counts.
Ms. Becker,
Yes, Bob.
you committed this crime. Isn't that correct?
I was
Objection asked and
instructed.
answered.
Okay.
It is repetitive. We sustain
Okay.
the objection.
And I'm going to repeat, you had all the items you needed to do so, including the experience as a notary. And how long have you been a notary at this time?
I don't recall.
You don't recall. But you knew that you were committing a crime when you used a notary seal that was not yours. Isn't that correct?
I think I've already answered this question.
Go ahead and answer the question.
Yes.
Okay. Now, you say that Ms. Skelton gave you this name, but you don't have any proof to show that's true. Isn't that so?
No.
Okay. So you could have easily, just as easily, have gone down the street and held up one of the local grocery stores and come back and say that Ms. Skelton told you to do it. Isn't that so?
Yes.
Okay.
Ask for an opinion, or I'm not even sure.
I'm not.
Objection?
Just move along. We overrule the objection.
And isn't it true, Ms. Becker, that you knew that if this insurance money wasn't paid out, that you wouldn't have received the bonus that you did get?
That's what Ms. Skelton told me, yes.
Okay. So you got money for doing what you did?
No, sir, I got money for performing my job, which is what she told me to do.
Okay. So your job was okay? It was okay that you committed a crime because you're saying someone told you to do it?
No, sir, it was not, and I am very sorry for that.
Okay. But in the past, you had produced other documents out of Ms. Skelton's office for your benefit, for the benefit of your friends and family, without her permission. Isn't that so?
No, that is not so.
And isn't it true that you had a partnership with the deputy sheriff there in town?
Yes, that is true.
Okay, you had a website. You shared a website with him. Isn't that so?
Yes.
Okay, do you think that played any part as to why the issue of why you weren't ever charged with any of these so-called crimes?
No,
Do you
sir.
think that played a part in
I
that?
can tell you exactly why I was not charged. I sat before a Texas Ranger who said to me, "Julie, here are the documents. Did you do this?" And I said, "Yes, sir, I did, and I'm terribly sorry." And he said, "You have two choices. You can either be a witness or you can be a defendant. That is why I'm here."
So the Texas Ranger gave you immunity. Is that what you're saying?
No, sir. Absolutely not.
Is this, all this testimony related to the insurance documents?
No, sir.
This is something else entirely? I mean, I understand what you're saying. She notarized documents she shouldn't have notarized, and she's saying that Ms. Skelton told her to do it, and I imagine if we brought Ms. Skelton back, she'd say, "I don't know what you're talking about." But I don't see, we've now had like 5 minutes of this, and I'm not sure where it's going. I'm not sure what it's about.
I apologize for that. Let me just be real quick, just to clear it up. And I didn't mean to waste anybody's time, but they bring Ms. Becker in here, what appears to me to litigate a case that's been dismissed. I don't know any other way to handle it other than to get into the specifics of what prompted her testimony.
I don't mean to speak for the entire board, but I get your point. I mean, I understand that, that there's something that's going on between the two of them, and Ms. Becker will say one thing, Ms. Skelton will say the opposite. And my question is, what does it have to do with the underlying offensive, either the conviction or the subsequent civil trial? And I'm not sure it has anything to do with either of those.
And if I may, they're trying to impeach her with some sort of extraneous bad act.
Okay.
Mr. Galvan defended her in that case, led her dismissal. He's familiar with this witness, so we allowed him to.
I got it.
And I
Okay.
agree with him. They're trying to prove a crime
Okay.
in front of this.
I get it. I just want to make sure I understand where we're going. I mean, I think we've covered it. I
appreciate that. I mean, my impression was they were slurring her with no foundation.
And I get that. I understand that. Maybe the rest of the board does too.
I think we get it.
We get it.
Okay, well, I apologize. I haven't been before a board like this before, and so I'm kind of here to...
If you want to proceed to try your case...
Didn't mean to do that, sir.
No. Yeah, you're free. If you have other questions, please ask whatever questions you feel are necessary. We're not telling you to quit, but we think we understand the purpose of the testimony, and it may be better served to go into another topic. But you make that call.
I can agree. May I confer with Mr. Lee?
Absolutely.
Ms. Becker, after Ms. Skelton's office was searched, and after these accusations were brought against her, did you not continue to be her client in any proceeding?
Honestly, do not recall.
You don't recall your divorce?
No.
Pass the witness.
Ms. Becker, did you leave Ms. Skelton's employ on your own?
I certainly did.
Why did you leave?
I walked out of her office and did not give her any notice because my conscience could no longer take the acts that were going on in that office.
Thank you. Pass it.
Any further questions?
Ms. Becker, did it bother you? Did your conscience bother you that you had falsified a name and falsified a notary proceeding?
Of course they did, yes. Very much so.
So then your conscience bothered you as to your own acts. Are you trying to say your conscience bothered you as to Ms. Skelton's acts?
Both.
That's the way.
Can I? I'm really
Yeah, we're at that point. Let's have the board members ask whatever questions.
Is this, we're trying the first case, not the will case?
Correct.
Yes.
This is the automobile case we're trying, not the will case?
That is correct, sir, and I apologize. I mean, the reason I came forward because it appeared to me that Mr. Veltman was attempting to do just that, and that he was bringing in witnesses, making these accusations that amounted to mere slander with no legitimate basis. And if he wanted to bring in Ms. Becker, you know, I knew of no other way to address it other than to do exactly what I'm doing.
The dispute is she's not trustworthy and should be disbarred because she has prior conduct consistent with what they're saying, and the defense is that isn't true, the prior conduct didn't occur. Is that what we're fighting over here?
Can I clarify just for a moment?
Well, I think the question was addressed to me, and I think this. I think that apparently the state here is attempting to bring up prior conduct, one of them being that insurance, a so-called insurance fraud matter, and that's why they brought in Ms. Becker. That's why I was addressing that. I didn't come here to litigate it. I didn't expect to be up here at all.
We're protecting the public because she's got a history of this, and you're saying she doesn't have a history of this.
I think you can. I think that would encapsulate exactly where I'm coming from, sir.
Just trying to understand.
May I respond?
Well, Mr. Veltman, I think what I'd like to have is one set of closing arguments. So I anticipate, I think I understand what your response is going to be, and I'd ask you just to hold that till the closing. And if we have any questions of the witness from the board, then we can do that, and if not, then we can conclude with the witness. Is there any questions of Ms. Becker?
Ms. Becker, did I understand you said that you don't remember who represented you in your divorce?
No, sir, I don't believe I was asked that question.
Okay, I'm sorry. I misunderstood.
Any other questions? Thank you, Ms. Becker.
Thank you.
Mr. Veltman?
Yes, I'd like to call Ms. Mary Steelman, please.
My name is Mary Ellington Steelman.
Did you work for Miss Patricia Skelton?
I did.
Did she ever mention to you a car accident case involving a client's son and homeowner's insurance?
Yes, she did.
What did she say to you?
I guess I would object to this. I didn't have the other witness. Do you want to go into these alleged extraneous offenses, or are they irrelevant?
I believe he's offering prior instances of misconduct on her fitness and character to continue as a lawyer. Am I correct?
Partially. Of course you're correct. If I may extrapolate, that I'm bringing these witnesses under 404B, I believe, and it's 405, I'm sorry. 405 specific instances of conduct because her character has been brought to the fore, and it's at issue now. And because of that, I'm allowed to bring in not just opinions, but specific instances. And so that is the purpose of these two witnesses.
I'll withdraw the objection. My impression was maybe we hadn't objected soon enough and had gotten a little far down the road in this court, so I was taking that opportunity now, but I'll withdraw it.
I'm sorry, could you repeat the question?
What did Ms. Skelton say about what she did in that case that I just mentioned?
As I recall, it was really soon after I had come into her employ, and she was telling me about another secretary that just didn't have the stomach for the work and all, and so she was telling me that she had an insurance case that wouldn't pay the amount unless the deceased had been living at home at the time of the accident. She said, I told her, the mother, to go home and make it look like he had been living there, even though he had been out of the home for some time, until after the insurance adjuster came, and she said he came and he bought it and paid off like a slot machine.
Were you working for Ms. Skelton at the time of the underlying incident regarding the will?
Yes.
Did you leave Ms. Skelton's employ on your own?
On my own? Yes, sir, I did.
Why did you leave?
Ultimately, I had witnessed so many things that were not only unethical, but I found out illegal. I didn't want to get sucked into being criminally responsible myself into any of these actions.
Were you a witness in the will case?
I was.
I'm sorry. What was your answer?
Were you?
He was. Thank you. I'm sorry.
Pass the witness.
Ms. Steelman, prior to the time you, as I understand it, you sort of volunteered to work for Ms. Skelton. Is that true?
Yes.
Is it because you had an interest in perhaps going to law school or something?
My husband works overseas and is gone a lot, and Mrs. Skelton had been our attorney on a couple of real estate matters, and I was interested, and she always needed more help. This was when she was county attorney.
The real estate matters she handled for your family, were those routine?
I think so.
Anything unusual happen there?
No.
Okay. But at any rate, you volunteered to work in her office as a result of having observed her actions and activities as a lawyer?
Yes, and that she was the county attorney at the time.
Is it true that when Ms. Skelton asked you to complete a W-4 application, you, under her words, panicked and asked if you could be paid in cash because you had not paid the Internal Revenue Service any taxes for several years?
That's not true.
Okay, thank you. Pass the witness.
No further questions.
Any questions, Ms. Stillman?
On the matters in which Ms. Skelton was your personal attorney, were they handled satisfactorily?
Yes, other than during the course, our home burned down, and she helped us acquire our neighbor's property, and she came to visit and asked my husband and I, she was involved, I don't know if I can just say this, but in a malpractice suit, and she asked us to hide some of her assets. And I felt kind of put upon, and my husband just said, no way, no how, I'm not going to do it. And I felt like that was a real overreaching. I mean, I almost felt like I needed to because she was my attorney. I don't know if that makes sense, that she was kind of representing me in matters, and I was very confused, but my husband was not.
I think you testified that you were a witness at the will contest.
Yes, sir.
That's what we've been calling the civil matter.
No, the criminal and the civil.
So you were a witness of both.
Yes.
Okay, thank you.
Any other questions? Any redirect across?
No, sir.
Okay. Thank you. Next witness, Mr. Veltman.
No further witness.
But just now realize I rested during his case. I rested.
Okay. You both rest, you both close? Okay. Give you a few minutes for closing argument.
The bottom line of this case is that Ms. Skelton was found guilty of a crime involving moral turpitude. The starting point is disbarment, and it is the burden of the respondent to come back and prove that she should be suspended rather than disbarred. And that's where we are. We've heard multiple witnesses about her character, her professionalism, her honesty, both sides. But when we look at the Philipov factors, we see that the forgery was committed in the course of her profession as an attorney. There is some question as to whether she has taken responsibility for that. There's been arguments over whether this civil case exonerated her, vindicated her. She has denied what she's been accused of on the stand. We've also heard rebuttal testimony about exactly what kind of attorney she is, what kind of boss she is, what kind of person she is. And I'm not going to go into all the details again. You've heard quite enough, I'm sure. I think that the respondent has not met her burden of showing that she's deserving of a suspension rather than a disbarment in this case, and I'm going to leave it at that. Thank you.
Mr. Lee?
Thank you. Please, the board. I agree with his description of where we are, which is she has been convicted of felony involving moral turpitude. She's never denied that. The record shows she voluntarily surrendered her license. We entered into an agreed interlocutory order. There's no argument about the nature of the offense and what the law requires. But now, having had that go final, she's entitled to come here and try to meet her burden of showing she is not a threat to the public and that merely suspending her during the time she's on probation will be what's appropriate. I would look at this, and the way I think of it from back when I was with the bar, is that in many regards it's a status offense. Her current status as a person on probation for a felony involving moral turpitude, it would look odd to the public to allow someone like that to carry on practicing law. But it would not look odd for a person like that, after having paid their debt to society, to have their privilege of practicing law restored, and it happens all the time. In fact, we have other degrees of offenses that you can be on probation for them, like possession of cocaine, and just keep on practicing law. It's quite all right. So the real issue is, I think, in making this decision between suspension and disbarment is somewhat what's good for her, what's fair to her, but more what's fair to the public and what's appropriate. And that's why we tried to bring the case to show that you have an isolated incident of a lawyer, and we weren't allowed to go into how this document came into being and all of that stuff, but that we're trying to show that it was done innocently, and the repercussions were that it resulted in a criminal prosecution that was successful. But that very same document that was supposed to have been the product of forgery was turned out, it was held by another jury to be a valid copy of a will. So in other words, you have these conflicting decisions, and I think that's kind of the essence of this in deciding public protection, is that the will would not have been admitted to probate if it was a phony, if it was a fake, if there was no will and this was a fabrication. So we have here the question of degree. We have one prosecutor, and we've heard some evidence that the prosecution may not have been motivated simply by what was right and just, but by some personal issues in the community. And I think we all could take notice that in any community, but particularly in the smaller communities, these sort of things can happen. So what has been the result? I mean, Mr. Veltman was trying to hold it against her that she professes innocence. I see nothing wrong with that. I mean, if you're convicted of a crime, you have to abide by the terms of that judgment and do what's appropriate, but you don't have to admit that you intentionally engaged in wrongdoing, particularly when you don't think you did, when you've pursued an appeal on it, or pursuing habeas relief, and have been, dare I say, vindicated by another jury. You know, Mr. Veltman talked about the standard of the proof in the two. Well, Mr. Harwood was required to prove that that was a valid copy of a will, and he was also, the jury found that Ms. Skelton, by a preponderance, did not intend to deceive. That doesn't change the fact that she's criminally convicted, but I hope it affects y'all's decision in trying to decide whether her conduct was the kind of conduct that was just wrong, and no one can justify it under any circumstances, or it was conduct that might have been done better, certainly had very serious repercussion in the criminal arena, but as it turns out in the civil arena, the document that she presented was a true document. And that is an odd state, to be convicted of forging something that was not deceptive or false. And that's what's important about it, is not a collateral attack on the conviction, but what do you do with someone like that? How do you judge the character of a person like that? Well, another way to judge is not just by the acts underlying and the repercussions, but also by the people who know her and have a reason to express an opinion. And we didn't bring disgruntled ex-employees who have themselves engaged in questionable conduct. We brought people who have responsible positions in the community and will have to be accountable for their actions and what they did. We brought one woman who's an elected county attorney who's supposed to prosecute the criminal laws, and I dare say she would not show up here to vouch for a person on probation if she did not strongly believe in what she was doing and if she was not herself prepared to answer the voters of her community and the people that practice there. And she said, amazingly, she volunteered she would hire Patty to work for her. I don't know what stronger endorsement there can be for a person's moral fiber, for a person's fitness to practice law, for the lack of danger to the public, than to have a person who prosecutes criminal law say, I would hire this woman. We also had Mr. Hurley, a respected member of his community, who knows about lawyers and knows of lawyers and has had direct dealings with her, and he will vouch for her character. His parents have used her, and he said that he would have no hesitation in using her. Then we had Nancy Barron, a board-certified criminal law specialist, come and say for the first time in her 30-year career, she's pursuing a writ of actual innocence. That's how much she believes in the underlying facts of this case and what's right. And Mr. Harwood, because of the objections, was not much heard from, but I believe you can deduce from his having appeared as an expert witness in a criminal case, having successfully defended that will in the contest and some of the comments he started to make, I think you can see that he came here as nearly a 50-year practitioner because it was the right thing to do. You can check the file. There's no subpoena for Tom Harwood. You can check the motion for continuance that got this hearing postponed and see what Mr. Harwood represented by his verification. I have a 50-year lawyer from Uvalde who's familiar with these people and the politics out there, and he has come here on behalf of Ms. Skelton also. So, you know, I don't know how to respond to the claim that she has not met her burden of proof other than to say I strongly disagree. And I didn't hear any of this innuendo and these statements by people who have, well, they have motives that may not be completely admirable, coming and making these accusations which were not strong enough to support a criminal prosecution. You know, they make a big deal out of these prior bad acts, but the main result of it was that after years of time to prosecute the cases, if he won or she wanted to, they were dismissed. And I don't think that's appropriate to put her on trial for not having committed a crime. So I would respectfully request that in considering this, in considering the totality of the circumstances, considering what the State Bar rules provide for, that you exercise the power granted in you to treat this as a serious crime, place Ms. Skelton on probation for the duration of her criminal probation, let her successfully serve that out as she has been doing so far. She will, by the time that is up, have been suspended for some 7-odd years. Nothing else has come up. They haven't come out of the woodwork to get her disbarred for all these terrible acts she performed during the time she was actively practicing. And furthermore, the bar knew about these allegations long ago, and they let her practice law until the criminal process worked its way through. And there's been no case against her brought by them on the underlying facts attempting to prove that she did.
Objection as to facts found in evidence.
Sustained.
I'm sorry. They have not presented any evidence of having pursued that. But on these bases, on all the factors that might be taken into consideration on making the decision about what is the appropriate resolution, I believe Ms. Skelton has prevailed, and the fair and proper thing for her, the administration of justice, and the protection of the public is to allow her to have her license back if she successfully completes her probation. And we thank you.
Thank you. Any rebuttal?
The purpose of the rules, as we've discussed today, is to protect the public, protect clients. It's obvious that Ms. Skelton was acting in the course of her duties as an attorney. We have testimony as to how she comports herself in regard to other cases. I think it's a pattern and practice. I don't think that the respondent has shown that she deserves leniency in terms of getting a suspension versus a disbarment. She's only been on probation for a short while. We don't have any proof of how she's going to behave the rest of her probation. And with that, I would leave it to you. You can weigh the evidence as you see fit, and I think you've heard plenty of it today. Ms. Skelton should not be practicing law. Thank you.
Mr. Beltman, she hasn't been practicing law for some period of time, is that correct?
I'm sorry, I missed that.
Has she not been practicing law for some period of time?
For some period of time, she has not. As far as I know, we have not investigated that.
At least in the state of the evidence, it looks like she's under interlocutory suspension. Is that right?
She is under interlocutory suspension, correct.
If there's been some evidence introduced that she practiced law during that period of time, I missed it. Was there some evidence introduced of that?
I'm unaware of any instances that she has practiced law.
It kind of, under this state of the record, looks like the folks in her district where she was practicing, the judge there gave her 2 years of probation in March of 2008. Am I reading that right?
She received 2 years of probation, correct.
On the criminal law case.
In the criminal law case.
And that's the status of the record of conviction as we stand here today under Section 8, right?
I believe you're correct.
What the commission is asking for disbarment, that's right?
That is correct.
Which would be a significant penalty beyond the 2 years that the judge in her criminal law case assessed against her. Is that right?
It is completely separate and distinct from...
I understand that, but there's a significant difference in time also. Is that right? For the two penalties to run out?
It's apples and oranges. I'm not sure I understand your question.
You got 2 years of probation in the criminal law case and several years that she stood without practicing at this point, as far as we know, as far as the record is concerned, and the commission's asking for more.
The crime of moral turpitude, she should be disbarred, not suspended as if we went to a panel and asked for a 3-year suspension.
Somebody said in the course of this that the probationary sentence was the absolute minimum the judge could have applied. Do you agree or disagree with that?
For a state bar, a state jail felony, I think that's the maximum, 2 two-year probation, you can probate a state jail felony.
That's all.
Mr. Milton, go ahead and have a seat. Now, there may be other questions for either one of you, but you can take them from the council table.
I have a question for Mr. Feldman. I just don't know what to make of the civil trial, the will contest. I mean, Mr. Lee brings it up every time he gets a chance. But I don't know if I've heard what the commission's position on it is, because clearly you've got a different, lower standard, but the will was held to be a proper will when she got convicted for it. So, I mean, I'm not sure, what impact should that have on our analysis at all, from the commission's point of view?
I believe it should have no impact at all. I think it's, under 802, I think it's an improper collateral attack on the underlying criminal judgment. And I would also reiterate that it's a different jury that has a different issue to be determined, whether, looking at all the circumstances, this will should be held valid for whatever reason. It's not specifically as to whether Ms. Skelton committed a criminal act. So what was that issue in that civil case has so many other factors involved that I don't think it's fair to compare the two and say that she was vindicated by the civil case at all. That's the commission's position.
Is it the commission's position that she was convicted of a serious crime or an intentional crime?
An intentional crime, and of which a serious crime is a subset, right?
Right. So are you saying only a serious crime or a serious crime and an intentional crime?
She committed a serious crime with intent. Did I understand your question? I'm sorry. Maybe I'm not understanding.
Well, there are two different. Under compulsory discipline, something can be characterized as either an intentional crime or a serious crime.
She intended to commit the crime, is what our position is. So it's intentional crime. And it's, I'm sorry, statutorily, the fraud, under the indictment at least, was pled as an intentional act. Right. I have that statute if you want a copy of it. I made copies for everyone. Would that be helpful?
Yes, I would be helpful.
Yeah.
Okay.
Sure.
We have it. We have it already.
Do we?
Oh, you do?
Any other questions for either counsel?
Since we have a criminal lawyer here. I did have a question about the state jail felony deal that Mr. Viltman talked about. It's been a while since I've done criminal law, but my recollection was 2 years isn't the maximum probation. It's the maximum term you could serve in prison with 10 years probation. Is that correct? Or has something changed since then? Or what is the maximum time of probation one could receive for a state jail felony?
Bob, the question is, what is the sentencing for maximum sentence for state jail felony, both time to do and probation?
Right.
Time to do would be 24 months.
Right, 2 years.
I believe. 5 years.
But my recollection was the most you could actually serve, because state jail felony, for some reason, even though it's essentially a fourth-degree felony, you can't get good time, or at least you used to could not, and you have to do it day for day. But you could get a longer period of probation, which I thought was up to 10 years. That the maximum you could serve in prison, incarcerated, is 2 years, or you could receive probation up to 10. And I'm just asking, what is the maximum if you didn't get an underlying sentence, if you did deferred or something? What is the maximum probation for a state jail felony you could receive? Does it exceed 2 years? Is my question.
Does the probation exceed 2 years?
Yes.
Yes, ma'am.
Yes. For how long?
I believe it's 5 years.
5. I couldn't remember if it was 5 or 10. Thank you.
And I have just been corrected as well that the maximum or the range of to-do time is from 6 months to 2 years, and then from 2 to 5 on probation. It has been a while since I've practiced criminal law too, but so I guess that would mean since she got 1 year state jail, she did not get the minimum on the to-do part. So
But she got the minimum probation.
she got the minimum probation.
Any other questions? Thank you.
Did you say, Mr. Veltman, that it's the commission's position that this civil trial in regard to the will contest is just not relevant to the issue that we're hearing today?
I don't believe it's fair to compare them and fair to attack the underlying criminal judgment. It's interesting, and I think that that's not my personal opinion.
It's fascinating, but from a legal position,
I think it's irrelevant.
does the civil trial have any relevance on the matter we're considering today?
Correct. I believe it is legally irrelevant.
Other questions?
Especially since we don't have any knowledge of what went on. We don't have any statutory guidance.
Is that based on the burden of proof being different?
Partially,
it does
but the burden
appear
of
that
proof
they
and the
answer the
issues.
same issue in each case.
The goal of that civil case was completely focused differently from what it was in the criminal case. And our statute is, I guess, under 802 about how we're supposed to read the underlying criminal judgment. We don't have a similar statute as to how we're supposed to take into account a civil case, except that I believe that you shouldn't be allowed to collaterally attack the criminal case.
I don't know if I'm allowed to object to his response, but it just seems to me that they've labored hard to keep us from knowing what went on in that will contest, and now they want to claim we can presume that it didn't have anything to do with any of this stuff. It ain't right. I mean, this is about what's right and wrong here, and this method of trying to impede her from making her burden of proof and then hold things against her that don't come in evidence because they won't let them is just not right. I had the people here. I had the man that tried the will contest. Any of these questions could have been answered.
And again, I'm not testifying. I'm not trying to get into the details of the will contest. I'm just saying that structurally, the burden is different. The standards.
Mr. Veltman, all you're doing is answering my question. Okay. Right. I don't take what you're doing as a trial of the will contest.
I'm sorry, I missed that last part.
I do not take what you're doing as the offer of proof of the trial of the will contest as against the record of conviction. You're answering my question.
Oh, thank you.
However, my question is, it looks like two civil juries answered the same question, two juries answered the same question in two different proceedings and came up with diametrically opposed answers. Is that because of the burden of proof that the civil case becomes irrelevant, or is there some other reason?
Again,
legally?
it's partially my understanding of the whole structure, the difference between criminal law and civil case, and the difference between a forgery case and a will contest is that on the one hand, on the one hand, it's the burden of proof. On the other hand, it's the whole focus of what a jury wants to do with that, whether for the purpose of finality, for the purpose of the family, whether they want to hold that a will is valid is completely different, whether they want to decide that Ms. Skelton goes to jail.
Mr. Belvin, what about the impact of the special special issue question directly addressed to that? In other words, you certainly have the judgment admitting the will of probate. Now, here we have evidence of the actual special issue answer that goes directly to that. Does that have? Is it your view or the Commission's view that has no impact on or should have no impact on our decision making?
I don't think it escapes the criticism that the issues that the jury is dealing with are completely different, and their focus is completely different. In a civil case, deciding whether a will is valid, whether the family can move on, I think that jury instruction, the special issue, I don't want to get into all the details, but I think it has different connotations for a civil jury is deciding a will. So I don't think it escapes that criticism, is my answer.
Do I understand that even I understand your position on the two different judgments, because the juries have been motivated in each case. But as to the interrogatory answer, is your response the same? It just has no. It should have no impact on our decision making. I'm talking about the specific interrogatory answer.
The interrogatory to the jury.
Yes.
It's question number 2 in the jury charge in the will contest
I
case.
reverted to a federal jury with a special argument. I'm sorry, special issue.
I think I understand your question, and I would say that the argument does not, our position does not change. And I want to add something about that. I'm not going to add something about that. Sorry.
Why are unproved allegations of prior questionable conduct relevant, but subsequent proven innocence is not relevant? At least the subsequent proven innocence involves the same exact document. The prior claims of misconduct have nothing to do with the will. So why is one relevant and the other not, other than your position that that's so?
The will contest, the question there was whether she was guilty or not. And our statute requires us to believe that she was guilty. But the issue about her morality, her character, was brought up by the respondent by bringing all these witnesses to testify that she was a good person. Under 405, we are specifically allowed to bring in specific instances of misconduct and prior bad acts in order to rebut all that. And so that's where that comes in as being relevant. And I wasn't trying to say that she's more guilty of the crime of forgery because she had prior bad acts. I'm only rebutting her character evidence put on by the respondent's counsel.
I understand why you did it. I'm just asking why you think that's relevant and the other one isn't relevant. I mean, you're trying to you're seeking disbarment on the basis of the forgery conviction, not on the basis that she has a history of being not competent to practice law, or not. I don't remember what the rule is, but not because she has a history of that.
I'm sorry. That is correct, and I would like to clarify that if that's a conception here, that I did not bring in the character witnesses to specifically say that she should be disbarred for her felony crime. I'm saying that she should not be allowed to be suspended. That is the lower sanction. And I'm rebutting specifically her witnesses that say her character would allow you to do so.
Mr. Feldman, is it your position that 802 makes conclusive the fact that she did commit forgery, and that anything in the civil trial that contradicts that conclusive conclusion is irrelevant? And that's the difference in the two offers of proof, or two areas of evidence?
I couldn't have said it better myself, and I didn't. Yes.
Anything else? Thank you both, and especially thank the witnesses for their testimony today. Conclude our hearings.